Hi, good afternoon, guys. After long back, we again conduct one constitution class after the introductory class. অনেকদিন পর আমরা আরেকটি কনস্টিটিউশন ক্লাসের আয়োজন করলাম আমাদের introductory constitution ক্লাসের পর. Our today's topic basically fundamental rights, fundamental duties, and directive principle of state policy. Basically, it is the very vital part of, pivotal part of our Indian constitution. এবং আমরা যেই পরীক্ষার জন্য প্রিপারেশন নিতে যাচ্ছি, বেসিক্যালি ICDS সুপারভাইজার, পঞ্চায়েত এক্সটেনশন অফিসার, CDPO, এই পরীক্ষাতে এই পার্টটার একটা বিশেষ গুরুত্ব রয়েছে. It has lots of importance and many questions directly come from these topics rather than those who are LD assistant aspirants. I must say, in case of their exam, in their syllabus there is no part mentioned by TPSC about Indian constitution. Still thereafter also we have to read, because more than 5 to 6 questions will come from this constitution part, and out of 5 to 6 questions, more than 3 to 4 questions will come from this part. So everyone, look at this video, enjoy this, and take the information about fundamental rights, fundamental duties, and directive principle of state policy. Okay, let's start. So first, we shall discuss the evolution of fundamental rights. We have to understand what about rights. We have to understand what about rights. Basically, right means the opportunity, the privileges of common people, which is guaranteed by, protected by our state. Our state means state may India, state may our small state Tripura, that is. With respect to the notion, we have to understand what is the place actually. Okay, what is the state actually? That is, we have to understand. So, rights. Basically, rights, according to Lesky, one famous professor of political science, Lesky said rights basically 3 types. One is natural right, one is natural right, one is moral rights, another one is legal or constitutional rights. Legal or constitutional rights. Now this constitutional right again divided into 3 different forms of right. One is social rights, another one is political rights, and another one is economic right. Economic rights. So why Professor Lesky divides the definitions of right? Because we are very much aware about our rights, and the concept about the rights in globe basically inspired from the lecture of the thoughts of Professor Lesky, and that is the distinctions of rights of Professor Lesky. Right now, the part of Indian Constitution. এবার যদি আমি Indian Constitution এর কথা বলি, the Indian Constitution basically that is also inspired from some aspects of other countries, some aspects of our freedom fighters doings. Okay, কেন বললাম এই কথাটা? Because the notion of rights traced back to Magna Carta of 1215. In art, when people are aware about these rights, the first instance we get from the Magna Carta of 1215. And thereafter, many countries, revolution, freedom movement, independence movement, that is taken place. And the revolution or the independence movement of America, the French Revolution, Russian Revolution, all these revolutions are very much connected to these rights. How to protect the rights of people, how to guarantee the rights of people. And Indian Constitution and India's fundamental right for people of India, citizen of India, it is nothing exception. Okay, the concept or the conception about India's fundamental right, if I say its evolution, that is inspired from 1215's Magna Carta. Thereafter, in 1895, one bill was introduced by Bal Gangadhar Tilak, and the bill was Swaraj Bill. এই স্বরাজ বিল যার মধ্যে 111টা 111 আর্টিকেল ছিল, and এই স্বরাজ বিলে in 1895 তখনকার সময়েও অনেক বেশি গুরুত্বপূর্ণ বিষয়গুলো এনলিস্টেড করা হয়েছিল. The matters enlisted in the Swaraj Bill, which is related to fundamental rights or which defines the evolution of fundamental rights, like right to privacy, right to equality, right to freedom. These are the aspects, but right to universal adult franchise, that was not mentioned. That time, this adult franchisee was restricted. A portion of people are eligible to cast their vote. What happened that time? Thereafter, that's why Swaraj Bill, it is a great source or inspiration for the evolution of fundamental rights. Thereafter, in 1927, this is also very important year. The Congress session, INC session was in Madras, and this session was presided by Mukhtar Abbas Ansari. In 1927, again, he raised the issue about rights of people or the fundamental rights. Thereafter, in 1928, when Simon Commission came in India under the leadership of John Simon, what happened that time? Motilal Nehru, the young Congress fellow, published one report which is also known as Nehru Report. This report also said the India's people's fundamental rights. What happened thereafter? In 1928, one Nehru report was published. This report also set the fundamental rights of the people of India. Thereafter, in 1931, Karachi session of Indian National Congress. Again, in 1931, the Karachi session of INC again officially takes resolution for the Indian Constitution, and one of the pioneer matter was fundamental rights of people of India. Here, right to freedom, right to privacy, universal adult franchising, this type of matter enlisted in 1931 session of INC. Thereafter, 1945. Thereafter, 1945, the report of Sapro Committee. The report of Sapro Committee, 1945. The formation of this committee also was very important, because Sapro Committee was the committee who sought the rights of all sections of people, minorities, disadvantaged groups, majorities, all the sections of people's right. So, according to this Sapro Committee, they divided rights in two parts. One part is justiciable and another part is non-justiciable. And the justiciable part is called fundamental rights. Justiciable part, it is called fundamental rights. It is called FD. And which is non-justiciable, that is called directive principle of state policy, DPSP in short form. So why fundamental rights and DPSP came in India? That is the evolutionary background. Without the Sapro Committee report, that was not possible. Okay? Later on, we discuss deeply what about its detail. Okay? Justiciable means here it can be decided or justified by the Apex Court of India, and non-justiciable means it cannot be justified by our Honorable Apex Court, that is the Supreme Court of India. These are the two words and its distinctions. Okay, let's visual forward the second part, the divisions of fundamental rights. The divisions of fundamental rights. Basically, fundamental rights, it is come under Part 3 of Indian Constitution. It is come under Part 3 of Indian Constitution. It is come under Part 3 of Indian Constitution, which contains Article 12 to 35, which contains Article 12 to 35. So we shall start from Article 12. We shall start from Article 12. Basically, Article 12 said the government, that is executive, and the legislative or the legislative of unions, how are formed in India. Basically, governments or the executives itself one broad organ of India. If we think on or we think with reference to the union has one government, it has executives as well as its legislature, and for the states of India the same thing happened. It is the executive and the legislature. Not only the states executive and states union executives, not only the states legislature or union legislature, all the local forms of government also included under the Article 12, and that is the government of municipalities, that means the local self-government, panchayats, district boards, trust, these are even all the statutory organizations which is basically come under the purview of Government of India, like LIC, ONGC, SAIL, etc. Basically, when all these agencies is doing any such work which breached the fundamental right, what happened? That time the issue moves to court and all these bodies are challenged in the court. That was the main aspects of Article 12. Here we clearly understand about we never can do anything which breach our fundamental rights, or which breach or breaches any of the individuals or organizations fundamental right. That time that person shall move to the court for writ jurisdictions. Later on we discuss about the writ jurisdictions. Okay. Then Article 13 basically it defines Article 13 said it defines the laws inconsistent with fundamental rights shall be void. If any law is made by our legislature and if it is breaches our fundamental right, we can't say that is law. We can't say that is law. যদি এমন কোন ল যেটা আমাদের ফান্ডামেন্টাল রাইটস কে ভায়োলেশন করবে, we can't say, আমরা কখনো সেটাকে বলতে পারবো না যে এটা একটা ফান্ডামেন্টাল, একটা law. Okay, this provision also enlisted under the part of fundamental rights in Indian Constitution. Okay, and The term law, according to Article 13, it has given one wide connotation, and this wide connotation basically meant if any law which you want to say the permanent law or the permanent nature of laws, basically where laws are made in legislative house. It may the state legislative house, it may the central or the union legislative house. Okay, and who are the assigning authorities of this law? Without the signature of president, this document never became law. So that's why I say if any of the law it breaches the fundamental rights issues, that time it can't be a law. Okay, that is the main aspects of Article 13. And in case of the TPSC exams, they will ask you define law according to Article 13. That time you have to write this content. This content is very important and very much precious content as far as my knowledge of concern. Okay, so the next or the main portion of fundamental rights. Next or the main portion of fundamental rights we shall discuss right now. Okay, basically fundamental rights. Our Indian Constitution has given these fundamental rights. Originally that was 7. And right now we have only 6 fundamental rights. One rights that is deleted from the list of fundamental right and it keeps as legal rights in Indian Constitution. Okay, and the right which is actually deleted by 44th Amendment Act 1978, that is right to property. And right to property now enlisted in Indian Constitution under Article 300A as legal rights. This is one important amendment in Indian Constitution. Really it is important. Okay, so the next part. This is very important, right to equality. We know that right now we have 6 fundamental rights. Right to equality, right to freedom, thereafter right against exploitation, then right to freedom of religion, cultural and educational rights, right to constitutional remedies. So right to equality, it is come under Article 14 to 18. Here 4 rights actually make this portion or included in this portion right to equality. It is very important portion for your exam. As far as your exam mandate, it is very important portion because right to equality, it has broader aspect. And in this broader aspect, we have to cover very precisely. We have to work smartly rather than hardly if you want to secure your job. So we have to read it very precisely. Okay, so let's equality before law and equal protection of laws. Very interesting. Equality before law and equal protection of laws. That is the main title of Article 14. One part is equality before law, and another part is equal protection of laws. Basically, in an apparent views, it is quite identical. No, it is not identical. Its meaning is different. Basically, right to equality, this concept taken from UK, and equal protection of laws, this concept taken from American Constitution, USA, from its 10th Constitutional Amendment. 10th Constitutional Amendment. Equality before law and equal protection of laws. This concept basically defined by one political scientist, namely A.V. Dicey, one famous professor, political scientist of UK. And his one famous book, Rule of Law. It is almost universal in UK. We know that UK has no written constitution. The Rule of Law, it is one pivotal book because the rules of the government or the governance in UK, that is done through the conventions, and rule of law as one conventions, it played very fertile role in UK. So equality before law and equal protection of laws. Right now, equality before law, no person shall be denied in the eye of law. Rich, poor, higher class, lower class, Brahmins, Shudras, no issue. All persons are equal before law. It is the main part. But there has some exception. Suppose to say, President of India. If President of India committed any of the guilt, is he punishable? Is he punishable? No. He gets the immunization due to his designation. Not only president, governor, any of the members of parliament, members of legislative assembly, ambassadors, they are basically got immunizations with respect to equality before law. Now, equal protection of laws. It is the modern concept of USA. Equal protection of laws means if anybody, any of the person, he can seek the help from the legal authorities, and the legal authorities are bound to give the equal protections of or with respect to the equal protection of laws. That is the main concept of equal protection of laws. The next, Article 15, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. That is come under Article 15. And this part is very important because it is the rule of state. And already I have said state means that is India. State means that meant Tripura, no issue. State are bound to keep respect or keep his looking without these grounds: religion, race, caste, sex, or place of birth. Because you acquire the citizenship of India beyond all of this. So you are not entitled to deprived on these grounds. This is come under Article 15. Now Article 16. Equality of opportunity in matters of public employment. It is also very important. Opportunity, basically, it is your privilege being an Indian citizen. Although our constitution has mentioned the term reservation, and it is for whom? It is for the disadvantaged sections of our society. It is for the disadvantaged sections of our society. But in case of public employment, everyone must get the employment in equal norms, and the state are bound to protect this. State are bound to secure this equality in the sense of public employment. This is the main aspects of Article 16. Thereafter, Article 17. It is another important. Abolition of untouchability and prohibition of its practice. Yes. In our society, we know that in the preface of our constitution, that is the preamble of our constitution, we enlisted some wide connotations or wide words. This is sovereign, socialist, secular, republic, democratic, justice, equality, fraternity, unity, integrity. This type of words we are enlisted in our preamble of the Indian Constitution. So, the untouchability, it is one evil practice. We must not differ the society, differ the individual by its caste, by its religion, by its creed. That's why this form of practice by Article 17 abolished in Indian Constitution, and it is your fundamental right. If anyone breaches your fundamental right on this ground, you may move to court. It is very important. Next, abolition of titles except military and academics. Basically, we know that the title Maharaja, that is abolished according to the Indian Constitution. The title Bahadur, that is abolished according to the Constitution of India. Except military and academics. We know that our highest civilian award, that is Bharat Ratna, we are awarded already many people. Isn't it? Even also foreigners, posthumously also we have awarded this our highest civilian award. In case of military award, peacetime gallantry award, wartime gallantry award, Shurya Chakra, Ashok Chakra, we were awarded, no? So This is come under Article 18, and this is the one of the fundamental rights which is come under right to equality. I think it is clear to everyone. The next slide. The next slide, that is the right to freedom. It is another important slide. Freedom. Freedom basically the word freedom, it is one greatest inspiration of one another political scientist, that is Immanuel Kant. In 1859, Immanuel Kant, 1859, Immanuel Kant wrote one book, namely On Liberty. The name of the book was On Liberty. In this book, Immanuel Kant mentioned what should be the freedom and how freedom is important to any of the common citizen of any nation. So that's why our Indian Constitution also inspired to enlist one particular article which is based on right to freedom. That is from come under Article 19 to 22. Protection of 6 rights. Very important. Protection of 6 rights. Basically, this is come under this Article 19(1). And Article 19 coincides with 6 forms of freedoms. These are speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence, freedom of profession. But there has also exception. There has also limitations, reasonable restrictions, and it is basically why reasonable restrictions are pushed in right to freedom. Due to integrity, sovereignty of our country. If our freedom exceeds the sovereignty of our country, that time that is not good for us. Our constitution, the values of constitution, that will be degraded. So this is protection of 6 rights regarding freedoms. Article 19. Now, protection in respect of conviction of offences. It is another important rights. Protection in respect of conviction for offences. Basically, conviction of offences. If you were breaching any of the law, or if you were committed any of the crime, you also equally deserve the protection in the eyes of law. If you are committed crime, you also can seek one advocate of your side. Okay, that is the aspects of protection in respect of conviction for offences, Article 20. Now, another important one, protection of life and personal liberty. Very, very important. Article 21, protection of life and personal liberty. Very important. And in this right, many fundamental aspects as rights are included in Indian Constitution, as like as right to environment, right to health, right to privacy, all come under right to life and personal liberty. Right to play, right to sing, all come under right to life and personal liberty. This is come under Article 21. Thereafter, another important article also included in this part, that is right to elementary education. Right to elementary education. Basically, this is come under Article 21A. This is right to education. Basically, every child deserves from 6 to 14 years early childhood care, ECCE, early childhood care education from his parents, and it is the legal responsibilities of his parents to give this education at least till 14 years of age. And this is come under Article 21A. Okay. Now, Article 22. Protection against arrest and detention in certain cases. Article 22. And in these aspects, the matter about double jeopardy is very fantastic. What about double jeopardy? Basically, suppose if you are committed one crime in a day, in the next day, in the same date, for the same crime which already got punished, you are not responsible to get you must not deserve the same thing in the same day. Suppose to say, আপনি করোনার মাস্কের জন্য আপনি সাপোজ একদিন মাস্ক লাগালেন, পুলিশ আপনাকে ফাইন করলো বা অ্যাডমিনিস্ট্রেশন আপনাকে ফাইন করলো, আপনি সেই দিনের জন্য সে ফাইনের যে রিসিপ্টটা দেওয়া হবে, সেই দিনের জন্য যদি আপনি মাস্ক নাও লাগান আর এই রিসিপ্টটা যদি আপনার কাছে থাকে, you are absolutely free because it is your fundamental right. Already you are valid for your breaching of laws. This is come under Article 22. Okay, the next, right against exploitation. Right against exploitation, that is come under Article 23 and 24. Okay, right now the third fundamental right, that is right against exploitation. It is covered two articles, Articles 23 and 24. Article 23 basically said prohibition of traffic in human beings and forced labors. Yes, any form of trafficking, it is breaches the fundamental rights of any of the individual. And for this trafficking, The government of India has enacted the Trafficking Act in very latest form. So, human trafficking, child labor, forced labor, it is totally non-permitted according to the Indian Constitution. The next, prohibition of employment of children in factories, etc. This is covered, come under Article 24. What happened in case of employment in factories? Factories especially, factories, mine factories, coal mine factories, in any of the hazardous workplace, children got exploited, and it is the rights of people to save him from any of the exploitation. That's why it is enlisted in Indian Constitution as fundamental rights. So, not less than 16 years of age, if any of the child worked in any of the hazardous factories, it is must be beyond the fundamental rights of him or any of the individual. So, the organization or the authority come under punishable offenses. This is right against exploitation. I think it is clear. The next, right to freedom of religion, Article 25 to 28. This is very much contemporary article right now. We know that India is going through the Hindu Orthodox, hijab issues, etc. So, right to freedom of religion or right to religious freedom, that is very important. And it covers 4 articles, Article 25 to 28. Article 25 said, freedom of conscience and free profession, practice and propagation of religion. You are the supreme authority who can choose any of the religion, who can practice any of the religion. আমি কোন রিলিজিয়ন করব, আমি কোন রিলিজিয়নকে ফলো করব, আমি কোন রিলিজিয়ন প্র্যাকটিস করব, it is totally depends on me. If someone intervene in this process, that time it violates my fundamental right. That time also, if any of the violation of fundamental rights occurs, automatically we shall move to the court, come under writ jurisdictions, to seek writ jurisdictions in the High Court or in the Apex Court, that is the Supreme Court of India. Next, freedom to manage religious affairs. Yes, we must or we should have this freedom to manage religious affairs. Because it is the matter of the religion whom I would marry. Suppose to say, I am on Hindu, I may marry to any of the Christian girl, Muslim girl, or any other girls, any other religious girls. According to the Constitution of India, I am free to marry anybody or any of the religious girls. If in this process anybody would intervene, that time it is same the violation of fundamental rights. That time also I may move to court with respect to the writ jurisdictions. Okay, the next article, freedom from payment of taxes for promotion of any of the religion, Article 27. Yes, that's why our religious places are free from the taxation. It is up to you to which religion or which religious or which worship places you want to give your charity. If anybody would compel, in that case, that is also the violation of fundamental rights. And the state, in case of India, it is the very positive concept. The state are never intervene any of the promotion of any religion. That's why our country is secular country. Our country is not biased to any of the singular religion. Okay? And due to this secular structure, we have taken the positive concept of secularism. What is the positive concept of secularism? We organize Kumbh Fair, as well as we give subsidy to Hajj Fair. All the things we try to arrange. That is the concept. And the second and the last one, freedom from attending religious instruction or worship in certain educational institution. Yes, India, in case of India, for the promotion of different languages like Arabic, we know that madrasa education that is prevailed in India, and you are very free to take any of the preaching parts from any of the religious education. And one good example, Prajapita Brahma Kumari. It is one Ishariya Vishwavidyalaya. They declared it. And here, the methods, shrines of religion are given to their disciples or the followers. The state must not give or must not intervene in this process. It is come under Article 28, right to freedom of religion. The next and very important one, cultural and educational rights. It is come under Article 29 to 30. Basically, culture and education. Culture basically depend on the people of the race or the people of the religion. For our tribal people of our state, we have 19 tribes, and each of the tribe has the specific religious mandates, specific cultures, and it is followed the whole state, the same prevalence found in the whole country. For culture or the spreading of culture, the language and script, it is very important. Basically, language, it has one part that is called dialect. And what about dialect? Dialect means the form or the expression of the language. Bengali itself one language, English one language. But how do we talk in English? Is it Latin form? Is it the form of UK or British form? The expression is different. This is called dialect. And our culture, it is basically based on script. Which script we have followed? Suppose to say, for our tribal people, that has till date the conflict. The language Kakborok, is it would be based on Roman script or any other script? Till date, it is a matter of conflict. So, culture without script, without language, never be developed. This is mentioned in Article 29. It is the responsibility to the state to the protection of language, script and culture of minorities. And minorities, this is basically the distribution of populations and its lower segments. Rights of minorities to establish and administer educational institutions. Yes, it is also another important article. And that time, right to minorities to establish and administer educational institutions. Educational institutions, it may 4 types. One is the total education system that is looked after by government entity. Another one, a part of education system that is looked after by government entity. Another by private entity. Another, it is totally looked after by any of the trust. Another, the administration of the institution, it may be by government, but the remaining portion is to be done by any of the private entity. These are the 4 forms of institutions, educational institutions basically found in India according to the constitutions. And if we are deprived from the facilities or the privileges of these institutions, that time we can say it is the breaches of our fundamental rights, and it is the basic responsibilities to the state to protect this right and to ensure the interest of the minorities to administer educational institutions. This is Article 30. And the last fundamental right, that is right to constitutional remedies. It is very important because all the 5 fundamental rights, if any of these rights are violated, how do we get the solution? This Article 32 will give the solution. This Article 32 will give the solution. And this is basically called writ jurisdiction of Supreme Court. If any of the fundamental rights violated by any of the institution, individuals, organization, that time people may move to Supreme Court or the state's highest court, that is the High Court, to appeal the solve of the issue about the breaches of fundamental rights. কোথাও যদি কারোর কোনো ফান্ডামেন্টাল রাইটস ভায়োলেশন হয়, তখন 32 নম্বর ধারা অনুসারে ভারতীয় সংবিধানের আপনাদের কাছে সেই রাইট আছে যে আপনারা আমাদের মহামান্য সুপ্রিম কোর্ট বা রাজ্যের মহামান্য হাইকোর্টে যেতে পারেন, গিয়ে এখানে একটা রিট ইস্যু করতে পারেন, অ্যান্ড সেই রিট যার বিচারক্রম পর্যবেক্ষণ করবেন the concerned court. Okay, basically writ jurisdictions are 5 types: habeas corpus, mandamus, prohibition, certiorari, quo warranto. These are the 5 writs. These 5 writs is very important to understand about the solve of the matters of fundamental rights. First is habeas corpus. First is habeas corpus. And habeas corpus, what is the meaning of this habeas corpus? Basically, habeas corpus said, its literal meaning or the Latin meaning is to have the body. To have the body. If any of the entity or the person who has detained to produce in a court in order to violation of fundamental right within 24 hours, the entity or the institution must send him to court. If this is not to be done, that time the writ jurisdictions are taken into action. Next, mandamus. Mandamus basically it is called we command. Mandamus basically it means is we command, and it is its literal meaning, and when it is enforced, basically it is enforced if you were not discharging your ultimate duty, that time mandamus may be issued. Next is prohibition. Prohibition, that is basically come under if any of the cases that is dealt by High Court and the High Court is not able to discharge his duties, that time Supreme Court may seek his permission and to move forward the case to the Supreme Court of India. It is come under prohibition. Next, certiorari. Basically, certiorari and prohibition, it is also the same case. In case of prohibition, it is the taken action, and in case of certiorari, it is not only taken action against the court or the tribunal, but also give the recovery. It is come under certiorari. And now quo warranto. Quo warranto basically defines what a court search the legal entity of the party by this quo warranto jurisdictions. So this is writ jurisdictions and it is come under fundamental rights, and this is our part about fundamental rights. So this is our class today. In the next class we shall discuss about the DPSP, the conflicts between or the primacy between DPSP and fundamental rights, and in the latter portion we shall discuss the fundamental duties, which is also mentioned in our constitution and it is very important part. Okay, this is our class today. Okay, bye bye. Thank you everyone. Everyone stay focused, everyone stay prepared.